Welcome to our symposium presentation on Supreme Court nominations and the confirmation process. Judges, as we know, assume the robe as a way of manifesting their commitment to the rule of law and their commitment to even-handedness and neutrality. And yet, before men and women take up the robe, they are, of course, people of the world. And part of that world is the world of politics. That is more than aptly illustrated by the confirmation process and the selection process for the judiciary. And it was part of the history of Matthew Byrne, Jr. as well, for whom this wonderful institute is named. Those of you who remember Judge Byrne remember him as an intellect in the law, as a man greatly caring about justice, about someone who manifested all of those qualities of integrity and capability and even-handedness that we would want in a judicial nominee. And yet, when he was nominated by President Lyndon Johnson in the spring of 1968, it turns out that his initial consideration and rejection had nothing to do with his capability and had everything to do with the fact that Lyndon Johnson said, "I will not seek, nor will I accept, the nomination of my party for re-election to the presidency of the United States," because at the time when Lyndon Johnson made that announcement, the two senators from California were Tom Kuechel and George Murphy, both of whom were of the Republican Party, and both of whom agreed within minutes of that announcement that they would engage in the process known as the blue slip, the ability of the home state senator to file a piece of paper with the Judiciary Committee to immediately stop the nomination of Matthew Byrne, Jr., not because he lacked the qualities of temperament or capability to be a member of the judiciary, but because, of course, this would reserve, at least speculatively at the time, the positions for a Republican president should he be elected. Of course, a Republican president was elected, somebody named Nixon, I think, and at which point something curious happened. California got two Democratic senators, Alan Princeton and John Tunney, and the two of them went to see Dick Kleindienst, then Deputy Attorney General, and Mr. Tunney reports that he basically said the following: "I now have it within my capacity to make a lot of trouble for you, and I will, for your nominations to the judiciary, unless you give me a third of the nominees to the district court bench, and you agree to a handful of other minor conditions." Mr. Kleindienst thought about it for all of a day or so and came back and said, "Fine, so long as you do not object to the president's nominations on purely partisan grounds," I hope they defined that, "you may have your 1/3 of the allocation for district court nominations." And the first person to be rectified in that respect was Matthew Byrne, Jr. And so it goes. Now, in all of this, I suspect it was quite difficult for Judge Byrne to go through that period of time. How would it not be to be told that you were selected and then deselected? You take that a certain amount a bit personally. I remember a colleague of mine, Bernie Segan, nominated for the Ninth Circuit near the end of the Reagan administration, had the same experience. Bernie was one of the most gentle and knowledgeable men ever nominated for the bench, and yet it had nothing to do with his knowledge and capability and everything to do with the fact that he was nominated in the last months of the Reagan presidency, when in fact we had lost the Senate. So that brings us to some of the questions we will explore. What are the appropriate criteria for the selection of men and women to the bench? Integrity, competence, experience, even-handedness have been mentioned. Presently, one would think, given the occupancy of the White House, Democratic affiliation might help. How about the role of the American Bar Association? This has been a role that has been suspended, re-engaged, suspended again, and now re-engaged. The ABA, it has been recently announced, will once again formally review for the White House the qualifications of judicial candidates. And it's not like they ever got out of the business, because when Alberto Gonzales said the White House wasn't interested in the ABA's evaluation because there was some suspicion on the part of the Republicans that their nominees were being treated less well than the Democratic nominees, a suspicion that has now perhaps been vindicated in political science literature most recently, at least so the political scientists, I don't know their partisanship, will have to check, claim the ABA was supplying their recommendations to the Senate Judiciary Committee, even if they were not of particular or direct relevance to the White House. The Miller Center at the University of Virginia in the late 1990s tried to neaten up the confirmation process, which was perceived as having become quite nasty in the wake of Robert Bork's failed nomination for the Supreme Court. And I'll just list very quickly to you some of the things these folks living in a quiet place in Charlottesville came up with for the reform of the confirmation process. They suggest that candidates should be identified well in advance of the time of a vacancy. I suspect that's happening, though I don't think the lists are being exchanged, which is actually their next recommendation. Senators should make a recommendation to the White House within 90 days of a vacancy. I think probably some presidents would wonder, why is it the senators are sending these names over to me? The White House should undertake its FBI and ABA investigations within 90 days of the vacancy. The ABA should report its findings within that same period of time. The White House and the Justice Department should consider eliminating personal interviews with the candidates to avoid the appearance of influencing judicial views. I had to smile at that one, given the fact that the White House counsel's office now has, I think, some 22 lawyers in it, and one wonders what they might be doing if they wouldn't be doing those personnel interviews. The next one is equally academic. If the nominee is non-controversial, the Senate Judiciary Committee should forgo a hearing. The Senate Judiciary Committee should clear nominees for full Senate confirmation within 2 months of the receipt of the nomination. And the prospective nominee should only have to complete a single questionnaire, one that would be consolidated in terms of the interests of the White House and the Senate. Good luck. The last confirmation proceeding that we witnessed was that of Justice Alito. By my count, he faced some 18 hours of questioning, something over 700 questions, most of which were redundant, almost all of which had no follow-up. Confirmation proceedings are, in short, quite difficult. Their difficulty has been increased by virtue of the fact that partisanship has become organized around wedge politics. The Supreme Court has expanded its role in various ways, as we know, and the electronic media thrives on good theater. We have with us today people who can analyze how this process is working or not working, how it can be improved, and to lead us in our beginning considerations of this is the Provost of Princeton University, whose scholarship in this area is well known because he has the leading text on this matter a text entitled "The Next Justice, Repairing the Supreme Court Appointment Process," published by the Princeton University Press in 2007. I happened to pull some of the interesting blogging that has been going on about this book, but rather than pay attention to the blogs, and I think the blogs are dangerous to pay attention to, and I have personal reasons for that. Provost Eisgruber.
Thank you. Well, let me begin, first of all, by thanking Dean Ken Starr and Doug and Shelley and the other organizers of this conference for bringing me out here to Pepperdine. As a provost these days, I spend too much of my time in administrative meetings around budgets and other matters, and don't have as much chance as I would like to get out and talk about the things that really animate my passions. And so it's wonderful to have a chance to be here with the other distinguished members of this panel, and especially to have a chance to talk to all of you about both the Supreme Court appointments process, and I'd also like to make this a bit about, for reasons that will become clear, the year that all of you are about to begin as judicial clerks. I have to say that I feel a little bit envious looking out at this audience and realizing that all of you are about to begin that year of your life, for both my wife, who is also a practicing attorney, and for me, and for I think virtually everybody I know who has done a judicial clerkship. That experience turns out to be one of the highlights of your career. Everybody, almost without exception, who goes through it finds it an extraordinary learning experience, one that produces a kind of bond of mentorship with the judge with whom they work, and insights into the judicial system and the nature of American law that I don't think can be obtained in any way. So congratulations are due to all of you for having secured these opportunities, and then, as I say, a little bit of envy as I look out at you, realizing what you're about to begin. The book that I wrote about the Supreme Court appointments process is actually a product, in part, of my own experiences as a law clerk, the intersection, in a way, of those experiences with a kind of emotional reaction to the last two sets of confirmation hearings. I was watching those hearings, as many of you were, I suspect, and at least in my case, the reaction was in significant part a reaction of frustration and exasperation, not really about outcome so much, nor about what Doug referred to in his remarks as neatness, or put it the other way, the contentiousness or political character of those hearings. I believe, actually, that Supreme Court confirmation proceedings are political and contentious by design of the Constitution, which set up a framework which could be, and in fact was expected by the framers to provoke debate from the get-go, and which indeed did generate contested confirmation hearings from the get-go. So I don't think it's the absence of neatness that is or should be exasperating to us. What was exasperating, at least to me, was the unedifying character of the discussions that went on. They were about extraordinary things. So here was John Roberts introducing himself at the beginning of his confirmation proceedings by declaring that he was nothing more than a baseball umpire who, once he took his seat on the court, would recede into the background, simply calling balls and strikes, no more important to the political life of the country than the particular identity of the umpire happened to be in the ordinary baseball game. Or here was the set of questions among that lengthy exchange, those lengthy exchanges that Doug alluded to about Sam Alito, where of all the things that could be asked of a potential Supreme Court justice, the questions were all about his membership in an obscure alumni group of Princeton University. I know this was important as the provost of Princeton at the time. We had reporters coming to Princeton to ask its students what they thought of the fact that Judge Alito was being asked questions about his membership 20 years ago. Perhaps he couldn't remember whether he was a member, he said, of this organization. And someone asked me, well, what do you think of all this? And I said, well, I think it means he's going to be confirmed. If this is all they can think to talk about, they're not really talking about the questions that matter, which is what kind of a Supreme Court justice he would be. As I said, that reaction had a kind of intersection with my experiences as a law clerk, because I thought there was a reason why this conversation was so unedifying, which was that we as a polity lacked a good understanding of what it was that a Supreme Court justice does. That if you don't have a good understanding of what a Supreme Court justice does, you can't really have a very good conversation about what count as appropriate credentials for being a Supreme Court justice. So in particular, there tend to be two kinds of narratives about what a justice, or for that matter, any judge, does in their work. One narrative is what I call the prim narrative. It's the one that says, well, judging at the Supreme Court or elsewhere is maybe a bit more than being an umpire, but it involves nothing political whatsoever. There's no political aspect to judging, and therefore we ought simply to look at the resume of the particular candidate, see whether their credentials are sound, and if so, they should be nominated, presumably by a president, and confirmed by the Senate. The second, polar opposite narrative about what goes on at the Supreme Court is what I call the kiss and tell narrative of Supreme Court judging. It says basically that none of it is like umpiring, and indeed the justices are just like legislators, and what's going on back there is nothing but raw politics in the court. So you have two narratives, one that says there's nothing political about this, it's completely untainted or unsullied by politics, and the other which says, well, it's just politics, it's just like the legislature operating with robes and a lot of judicial paraphernalia. I think all of you probably already appreciate, if not, you will come to appreciate over the course of your clerkship, that in fact judging is much more complicated than either of these two narratives would suggest. There are ways in which judging does participate very importantly, especially at the Supreme Court level, in political things. On the other hand, what judges do and the way in which they participate in the political system is quite different from the way in which legislators do. And what I want to do in my remarks today is to try to set out for you the different way in which Supreme Court justices in particular are political, and then say something about what that means about how it is that the President actually and the Senate both ought to approach the problem of appointing Supreme Court justices. So let me start by observing that for all the unedifying characteristics of these hearings and debates, there's one thing that senators on both sides, and they flip. There's, you know, they're either on the deference side or the non-deferential side, and all the ones who used to be on the deferential side saying defer to the choice of the president, are about to be on the non-deferential side, I predict, over the next 4 years. But they all tend to agree on this. They say, well, what the hearings should be about is the judicial philosophy of the nominees. It shouldn't be just about their politics, and it shouldn't be just about their legal background. It should be about this middle thing, judicial philosophy. But then they have no coherent account of what a judicial philosophy is, so things do tail off, and you don't get the follow-up questions, as Doug said. So what I'm going to try to do here, and I'm going to build a little bit on the very fine remarks that Professor Amar made at lunch, is to say something about what a judicial philosophy is. And so let me start with the first of about 3 main points that I want to make. The first point is that it really was absurd for John Roberts to claim that he was going to be nothing more than an umpire on the Supreme Court. Justices cannot be umpires, and they cannot be umpires for a very simple reason, which is that the Constitution of the United States doesn't permit them to be umpires. It doesn't permit them to be umpires because it presents them with questions far different from the ones that a baseball umpire has to deal with. The baseball umpire has to figure out whether or not a pitch thrown at somewhere around 90 miles per hour is crossing the plate between the knees and the shoulders or something like that. It's never quite the strike zone that they actually call, and that's hard, right? It's very hard to do that, but on the other hand, the rule itself is pretty clear, and if you get something, for those of you who are baseball fans, if you get something like K-Zone that they have on ESPN that shows you exactly the strike zone, it's pretty cut and dried. Either it's in or out, or it's right on the edge. The Constitution of the United States says, and I'll pick my favorite clause for these purposes, but you know there are many others, no state shall deny to any person under its jurisdiction the equal protection of the laws. Well, that's a lot different than saying that the ball has to cross the plate. In order to figure out whether or not that rule has been implicated in some way, abrogated, violated, you have to know what it means for the laws to protect people equally. And in order to understand what it means for the laws to protect people equally, you're going to have to draw on controversial judgments about what it means to treat people equally. No judge who has ever served on the Supreme Court, liberal or conservative, has avoided the need to draw on those kinds of judgments, which is why none of them have been umpires or look like umpires, and all of them, liberal or conservative, have been much more prominent than the ordinary umpire once they get on the court. Values matter, in other words, to a judicial philosophy and to how one adjudicates constitutional cases, and they matter if judges take their jobs responsibly, not because they sometimes fail to do so. That's true, I think, in all courts. It's especially true on the Supreme Court for a simple reason. There certainly are cases where perhaps all of us in this room with our legal training would agree about how those cases ought to be disposed of. None of those cases ever reach the Supreme Court. You may see them in your clerkships at the district or appellate court level, but the Supreme Court's reason for taking a case, the only way you get a cert petition granted, is by telling the court that there's an issue here that is not only important, but sufficiently difficult that, for example, circuits have divided about it, or that lawyers in general have disagreed about it. It has to be the kind of question about which two very good, very skilled lawyers can disagree. It can't be the kind of question where just everybody agrees about what the answer is. Second point, so that tends to the kind of kiss and tell side. It says, look, it really is, at least in these cases about the Equal Protection Clause, it really is about values, and it really is about something like politics, at least in the sense that ideology matters. But point number two, and one of the things that I think is so important about serving in a judicial clerkship, the way that judges go about deciding cases is very different from the way in which legislatures go about deciding issues that involve contested values. So let me mention two different ways, and the second one will be especially important, but two different ways in which that's so. And one of them I want to draw on one of the experiences I had as a law clerk, and as you will find, every once in a while you have these experiences just by chance that suddenly make something clear about these institutions that otherwise wouldn't be so. When I was at the Supreme Court, I used to like it when my friends would come visit and I had a chance to give them a behind-the-scenes tour of the building itself, which is really quite magnificent. So I was doing this on one Saturday with a friend who was interested in and eventually went into electoral politics, and showing him the back corridors of the court, which were completely empty and silent. And after all, it was a Saturday, and he said to me, because all the justices' chambers are along these corridors, he said, you know, I'll bet on a day where the court's in session, these corridors are just filled with people running back from one chambers to another. And you know, he had in mind the halls of Congress on a day where Congress is, which looks just like that. And I sort of stopped short, and I said, you know, because this had never occurred to me, actually, I haven't been in the building, I said, you know, actually, when the court's in session, it's exactly the way it is today. Which is that, in fact, if you're walking in the back halls of the Supreme Court on a day when it's in session, it's very, very rare to meet a justice. It's even rare to meet a clerk walking in the halls. Usually what you meet are the security guards who are looking at anybody who might be walking in the halls. And there's a reason for that, and there's a reason. The reason is that what the judges, the justices of the court, all believe is their job is to render their best judgment about what the law is in a particular case. They may disagree partly on the basis of values that they hold, and their judgment about the law in a particular case may not be one that can be reached without recourse to values. But nevertheless, they believe that their job is not about horse trading, which a legislator's job really may be about. Being a good legislator may require horse trading. Judging doesn't involve horse trading. It involves reaching your best judgment about what the law means in a particular case. And I suspect that proposition would get, I'm very confident, a 9-0 vote from the current justices of the Supreme Court. In a way, what that means is that the role of the Supreme Court, far from being an entirely apolitical or value-free institution, is in fact to ensure that certain kinds of values enter our politics with regard to certain kinds of issues. When an Equal Protection Clause case comes to the Supreme Court, it's not that it's going to be decided apolitically, it's that it's going to be decided by 9 people of integrity, legal skill, and judgment, making a sincere decision about how values, constitutional values, contested constitutional values, apply in that case. Here's the second very important difference, which was one of the things that connects to Professor Amar's remarks at lunch today. Judges have ideological values. They also have procedural values. Those procedural values attach to things like the idea of jurisdiction, the idea that a court ought not to decide a case when it does not have jurisdiction over it. They involve judgments about things like deference, the idea that certain kinds of issues ought to be decided by legislatures and not by courts. I don't mean to suggest that any of these procedural values are uncontroversial or that they're unconnected to substantive political values. They're often very controversial, but they're also very important to the way that judges decide cases. And sometimes judges will decide cases very differently from the way that legislatures will, because they may decide, it's a matter of ideology, for example, that they think the Equal Protection Clause or that equality requires that certain kinds of rights related to minimum welfare be recognized, but as a matter of procedure or institutional values, that it's no business of a court to be saying that that's an obligation that ought to be discharged by a legislature. So that's the second point, which says even though this enterprise is political in important ways, particularly at the Supreme Court, it's not political in the same way that legislation is. So that brings me now to my offering to you about what a judicial philosophy is, and here I'm going to connect one more time with Professor Amar's excellent remarks, which is to say a judicial philosophy is the interplay between a particular judge's ideological values and their procedural or institutional values. In my book, I call it a pattern of selective deference, a view that it's okay for the court, in fact, desirable for the court to intervene on some things, but not on other things. In Professor Amar's language from his talk at lunch today, it's an answer to the question, what do you think courts should be active about? Right? Professor Amar's comment to you, his insight was that there are various kinds of activism, and in fact, sometimes a court, in order to avoid being active on one dimension, will have to be active on another dimension. A judicial philosophy is an answer to the question, what ought courts? When are courts justified in being active about something and intervening in questions which one might think ought to be assigned only to the electoral branches? Now, whenever nominees get this kind of question at their hearings, what they always say is, never should a court be active. I don't believe in that. I believe that the job of judges is simply to interpret the Constitution as written, and then you can play this out for a little while further. But when judges get on the Supreme Court, every single justice, maybe there's some obscure justice in the 19th century, I don't know who's an exceptional this way, every 20th century justice has believed that it is sometimes desirable for the Supreme Court to intervene on controversial political issues on the basis of controversial judgments about constitutional language. It's not that they just believe that the court should intervene when the Constitution is crystal clear. They believe that the court should sometimes intervene when 5 justices on the court think that the Constitution prohibits the legislature from acting and 4 feel otherwise. Every justice to serve in the 20th century has thought it's a good thing for the court to be active about something, and a real confirmation process, the right kind of nomination process, would focus on what their answer to that question is. Final observation now, and I will turn things over to my panelists and look forward to talking further with you during the question period. The focus always gets put on the confirmation process and the Senate. One of the reasons I'm really delighted that Jan Crawford Greenburg is here, and I'm a great admirer of her book, is because I think the most important part of the appointments process is what goes on before confirmation, that is driven by the nominations process. So having said what I've just said, I want to say a little bit about what I would hope President Obama would be thinking about right now as he prepares to make what will almost certainly be multiple nominations over the course of his presidency. One is simply to recognize that fact, that he is going to be making multiple nominations over the course of this presidency. I think it's an easy bet that he will make at least 3 during his first term. If he serves 2 terms, I suspect he will appoint 5 justices to the Supreme Court, the most of any president since Dwight Eisenhower. If that's the case, I think that President Obama ought to be thinking not simply about which candidate he'd most like to appoint, but what his slate of nominees ought to look like. To do that, he's going to have to make a certain kind of choice. He's either going to have to decide, as many are calling on him to do right now, that he would like to appoint liberals who are kind of in the mode of Antonin Scalia, but on the other side of the spectrum. So if you read these blogs, and I share Doug's skepticism about them, but I do occasionally look at them. If you read these blogs, there are a lot of people who are saying, well, what we need right now, these are people on the left who helped to elect Obama, what we need is a liberal equivalent to Antonin Scalia. And I think that would be quite consistent with the pattern we've seen from recent conservative presidents if President Obama wanted to follow it. But there's another track he could take, which is to decide that as a matter of institutional value and the role of the constitutional system, that would be an undesirable thing to do. That is, that he might decide, even if he continues to have very high popularity and strong support in the Senate, that there are independent reasons why it would be desirable, good for the court and good for the country, to appoint a set of moderate liberals. That, I think, is the most important choice he has to make. My own hope would be that he makes it in the direction of appointing moderates. I'm happy to say some things about that if people are interested during the question period. Thanks.